In estate planning, asset titling refers to how you hold title to your different property. You might hold title in different ways to maybe a bank account or a brokerage account or even your real estate. You might hold title just in your name alone. So if you look at your bank statement and it just says your name, that means you hold title individually. If you look at your bank statement and it says your name and your spouse's name as joint tenants, that means you hold title as joint tenants. Asset titling can be really important in determining who will receive your property after your death. If you hold title to your property jointly with another person, if it says your name and your spouse's name as joint tenants with right of survivorship, that means that on the first of you to die, that second person, whether it's your spouse or a sister or a friend, that person is going to receive those assets as a matter of right. If you hold title individually, when you die, unless there's a beneficiary designation for the property that you hold, then that property is going to go through probate, and your will, if you have one, will determine who receives that asset. If you hold as tenants in common with a second person, that means that your property again will pass pursuant to the terms of your will. Asset titling can help avoid probate in that if you are joint tenants with someone, then on the first of you to die, the other joint tenant or joint tenants will take title as a matter of right, and that asset will not have to go through probate. In Pennsylvania, if you have joint accounts or joint ownership of property, it can also potentially reduce the inheritance taxes that are due. So while there aren't inheritance taxes between spouses, there would be inheritance taxes if you owned a property jointly with a child. So the Pennsylvania Department of Revenue will view that account as 50% owned by your child and 50% owned by you. When you die, there will only be inheritance taxes on that 50% that is owned by you.